Okay, great. All right, so we have about 90 people who have joined us today. I see in the attendees column. So this was a very popular session. I would like to do more on this topic because it is one that we get a lot of questions about, especially not necessarily because we have a lot of individuals who are facing eviction, but there's a lot of confusion around eviction versus notice to vacate versus other levels of essentially a landlord notifying a tenant that they've violated their lease in some way. So I think that David's here. He's going to be clarifying some of this for you all, and also, in addition to that, explaining the evictions process in Maryland and what that actually entails. So if you are working with an individual who is being evicted, you're aware of the process and they have the information that they might be asking you questions about. Although I still recommend referring people to Maryland Legal Aid, to Disability Rights Maryland, if they have specific legal questions that you are not qualified to answer if you're not an attorney. So thank you everyone for joining. I'm Chelsea Heyman. I'm with the Maryland Department of Disabilities. And today we will have David Prater from Disability Rights Maryland giving us a presentation on the evictions process in Maryland. And what we will do is some housekeeping. Please put any technical issues or questions in the chat. I will monitor the chat, and you're welcome to also use the Q&A if you have questions. Some of these questions we will either hold to the end or we will answer live, just kind of depending on how they fall in the presentation, but I'm going to aim to get all the questions answered at the end. If your question is not answered in this session, I will go ahead and bring those remaining questions to David so we can follow up and get your question clarified. So without further ado, David, I will hand it over to you.
Okay, great. Thank you, Chelsea, and thank you everyone for being here today. I am going to share my screen for a PowerPoint presentation. So hopefully everyone will be able to see this. I'd like to so we'll go ahead and get started here. My name is David Prater. I am a managing attorney at Disability Rights Maryland. For those of you who do not know me, I am the manager who do not know about Maryland Disability Rights Maryland. Excuse me. We are the protection advocacy agency for the state of Maryland. We are federally mandated to advance the civil and human rights of people with disabilities. And Disability Rights Maryland protects the rights of persons with disabilities to be part of their community by advocating for the expansion of safe, decent, affordable, and accessible housing. We have a fair housing practice group, and part of that practice includes providing representation to individuals who are facing eviction based on their disability. And we'll get into what that looks like a little bit later. But for the time being, I think I just want to jump right into the eviction process, because I know that's what a lot of folks are interested in. There's my contact information or my email, and you can always feel free to shoot me an email. It may be that I'll refer you to our intake line if it's a complicated matter. Or if there's something I can answer for you immediately, I'll try to respond to you soon. So we'll start with the sort of straightforward principle, I think, which is what are your housing rights? Now I think we need to start with this understanding, which is every eviction in Maryland has to go through a judicial process. There is no self-help eviction. What I mean by that is the landlord cannot change locks. He cannot call the sheriff. He cannot call the police. He cannot turn off utilities. He cannot turn off water. Pardon me for saying he, but these are not things that a landlord can do on his own. Landlords must go through Maryland courts in order to evict tenants from the property. And they can only do that when they have an order from the judge and when the sheriff executes that order. And basically what eviction cases are is a dispute over who gets the right to occupy residential premises. Is it the tenant or is it the landlord? Who gets the right to possession? And that's what a court hears in eviction proceedings. So, why can a landlord seek to evict you? So, this is a pretty simplified approach, but there are three chief reasons that a landlord will seek to evict a tenant. One, the tenant breached a term of their lease. Two, the lease has ended and the landlord has decided that they do not want to continue to rent to the tenant. We can talk about how that might interact with fair housing rights for people with disabilities. And three, the tenant hasn't paid rent. So how does these evictions occur? Well, it depends. Excuse me. So starting with the first reason for why a landlord can evict you is a breach of lease. So the first step in this process is a written notice explaining that the landlord is evicting the tenant because the tenant has breached a term of the lease. Sometimes this is what we call a pre-filing notice, which means that the landlord is requesting that the tenant be out of the property, or the tenant, or the landlord will then file a suit in the District Court of Maryland seeking possession of the residential premises. These pre-filing notices under Maryland's breach of lease statute are either 30 days or 14 days when there are instances of imminent threat. So, if at the end of that notice period, the tenant has not vacated, then the landlord may file a complaint in court. The landlord cannot file a complaint before that notice period has expired. So this is something that can happen frequently. Sometimes landlords will send 30-day notices, and the next day they will then file a complaint in court. That is not the right procedure. A landlord has to wait for that notice to expire. They have to wait for those 30 days to pass before they can even file a complaint in court. So after the landlord files a complaint, the court will then schedule a trial, and the court is really trying to decide three things. One, was there a material breach? Two, was the material breach substantial? And three, does it warrant an eviction? So that last number there, does it warrant an eviction, is sometimes what we call an equitable prong of this statute. And really what the court is trying to decide is, well, is this really an issue that merits someone being evicted? So maybe as an example, let's say there's a lease and a provision of the lease prohibits a tenant from keeping potted plants on their balcony. And the landlord sends a 30-day notice, the tenant blows it off and says, oh, what is this about? That's a little silly. The tenant doesn't leave, landlord files a complaint, the trial is scheduled, and then the court is going to hear a case about whether or not there was a material breach, whether it was substantial, and whether it warrants an eviction. Now, I couldn't tell you exactly how that might turn out, but I think, the purpose of that example is to say, not every breach of a lease is material, and not every breach of a lease warrants an eviction. The next reason a landlord could evict a tenant is what we call a tenant holding over. So in this instance, a landlord has to give written notice that they will not be renewing the lease. They have to give this notice before the lease expires. So in Baltimore City, they have to give that 60 days notice, as well as in Montgomery County. And in other jurisdictions, it's 30 days. So if the tenant remains on the property after the expiration of the lease, then the landlord must file a complaint in the district court alleging that the tenant is holding over. And then the court will schedule a trial date, and the court will decide, 1, was there a lease? 2, has it expired? And 3, was the tenant provided written notice? Similar issue here in that there has to be an expiration of the lease before the landlord can file. So again, the landlord cannot file a complaint right after they've sent this written notice, this pre-filing notice. They have to wait for the expiration of that notice and of the lease in this instance before they can file their complaint in court. The third action that a landlord can take is when a tenant fails to pay rent. As of October 1, 2021, Maryland landlords must provide a written notice of intent to file a complaint if tenant does not cure failure to pay rent within 10 days. And the notice must be provided on the judiciary's form. So there is a pre-filing notice now for landlords for failure to pay rent. Another thing that is required of landlords is they must be registered if the local law has, or local jurisdiction has, a landlord registration requirement. So if the tenant does not cure that rent within 10 days, then the landlord may file a failure to pay rent complaint. And then the court will schedule a trial to determine if the tenant did or did not pay the rent. Now that sounds pretty straightforward, right? It's pretty simple. Did you pay the rent? Did you not pay the rent? But sometimes what happens is tenants will think they are paying their rent. They may be a couple of days late, and a landlord will assess late fees or administrative fees or other fees because the tenant was late. And so when the tenant pays his rent, the landlord may apply some of that rent to some of those other fees and then say, oh, well, you paid those fees, but you didn't pay your rent, and so we're still going to court. So these can actually be fairly complicated and require looking at ledgers, rental ledgers, to determine how a landlord applied rent from the tenant or payments from the tenant. A tenant is entitled to see their rent ledger at any time. And they can ask that of their landlord at any time. Sometimes it can be a little bit of a challenge to get, but you got to keep asking for it, and keep at it. So after the trials are held, right, that's the last step in each of those actions. If the landlord receives a judgment for possession of the unit, the tenant then has 4 days to appeal that judgment. After the 4th day, the landlord may then request what's called a warrant of restitution. The warrant of restitution that a court orders is basically what allows the sheriff to go to the premises and physically evict a tenant. So it is only the sheriff who can carry out this eviction. The landlord cannot do it. No one else can do it. Only the sheriff. In Baltimore City, a landlord must provide 14 days notice prior to the date of an eviction. For failure to pay rent cases, tenants actually have what's called a right to redeem. So if I can back up just a little bit here, if the court has a trial and determines, no, hey, tenant, you didn't pay your rent for the month of March, a tenant has the right of redemption up to the very day that the sheriff comes to the door. And what the right of redemption means is the tenant can pay the rent and stay. So if a court ordered or a court judged that a tenant did not pay $500 in rent, the tenant has up to the eviction date to pay that $500 in rent in order to stay. And tenants can exercise that right no more than 5 times in 1 year, that right of redemption. So I do want to discuss special rules for subsidized housing. And because I know a lot of folks work in subsidized housing and work with people who reside in subsidized housing. So there are some additional rights that residents of subsidized housing have. And I'm just going to go over some of those rights briefly. So the first right is to have your rent and income calculated correctly. And this can actually be a lot more complicated than what it seems. We've seen this a lot during COVID, where people have had sporadic income, they've been laid off from work, and they've tried to report income changes to landlords, but the subsidized landlord is not processing those. Tenants have the right to have their income and rents calculated correctly in subsidized housing. And in public housing, that means no more than 30% of your income it goes towards your rent. For tenant-based vouchers, no more than 30% of your income goes towards rent and utilities. For project-based vouchers, it's actually the same, no more than 30% of rent and income, or rent and utilities for your rent, but many times utilities will be provided by landlords in project-based voucher units. In HUD, project-based rental assistance units, no more than 30% of income towards rent. Low-income housing tax credit properties, they're a little bit different. The rents are not based on a person's income, but rather as a percentage of area median income. And what landlords are looking for during recertification is whether or not a tenant income qualifies. And so they have to be below a certain percentage of area median income. And so sometimes there can be disputes about whether the tenant is actually below the area median income rent. And I'm sorry, I kind of jumped over some things, but is everyone, maybe I can just check in, but are folks familiar with public housing, tenant-based vouchers, project-based vouchers, HUD project-based rental assistance, low-income housing tax credits? Just gonna check the chat there real quick. So I'm getting lots of yeses, so we will move to the next pieces of it. So another right that residents in subsidized housing have is called good cause provision. And what good cause means is that landlords can't just decide to end your lease, right? We talked earlier about the tenant holding over, which is when a landlord decides, you know what, I just don't want to rent to this person anymore, and so I'm going to end the lease. In subsidized housing, where there's not a strike through, the landlord cannot do that. The subsidized landlord must have good cause. And Maryland courts have held that what that means is essentially a landlord has to show that there was a material breach, that it was substantial, and that it warrants an eviction. So in subsidized housing, really, the landlord can evict you when you have breached your lease. Now that's true of public housing, project-based voucher housing, HUD project-based rental assistance, and the low-income housing tax credit program. It is not true of a recipient of a tenant-based voucher. A landlord can decide that they are not going to renew the lease for a resident who uses a tenant-based voucher. Another right of residents of subsidized housing, and this is fairly recent, is a 30-day notice of termination. The CARES Act that was passed in 2020 now requires a 30-day notice of termination for any reason before filing a complaint for eviction. This is in addition to any state pre-filing notice. Now, what the guidance that HUD has given says that these two notice provisions under the CARES Act and under state law, they can run concurrently. So here's a good example. Public housing residents, if they don't pay their rent, they will now receive or should receive a 30-day notice of termination prior to the landlord having the right to file a complaint. The landlord must also serve the tenant with that 10-day notice of intent to file required by Maryland state law. So residents in subsidized housing may get a lot of paper, and it may be very, very confusing when they're facing eviction. So this 30-day notice requirement under the CARES Act extends to public housing, project-based vouchers, HUD project-based rental assistance, and the low-income housing tax credit program. I'm going to come back to the project-based voucher just at the end, because I was saying just how confusing this can be for tenants. And I'd like you to keep that in mind for project-based voucher assistance. Grievance process. So residents of public housing have an opportunity for an administrative hearing before an impartial party regarding an adverse action, and most housing authorities say inaction as well. But this does not include evictions because of threats to health, safety, or the right to peaceful enjoyment of the premises, as violent or drug-related criminal activity on or off the premises, or felony convictions. And this is a right really for public housing residents. So just to give an example, let's say a public housing authority says to a resident, you know what, you're breaking the house rules, that's a breach of your lease, and therefore here is a 30-day notice of termination that we're giving you. And that's consistent with the CARES Act, and that's also consistent with Maryland's breach of lease statute. A resident then has the right in public housing to say, I don't agree with that decision. I would like to exercise my rights under your grievance process to understand why it is you're deciding to evict me. And there are typically two stages to this. One, there's an informal stage where the landlord and the tenant will meet to see if there's some resolution. And then there may be a more formal grievance hearing where the tenant has the right to put on their case and the landlord has the right to put on their case before the impartial party to decide whether or not the notice of termination should go forward or not. Now, after this grievance process is exhausted, that doesn't mean the housing authority can then evict the tenant. The housing authority then has to go through the judicial process to evict the tenant under Maryland's breach of lease statute. Or also the failure to pay rent statute. This is another right that residents of some subsidized housing have, which is a meeting with management within 10 days of receiving a notice of termination. Now, unlike that formal grievance process that public housing residents have, a meeting with management is less formal. I've had some of these that are productive, and I've had some that are not so productive. Because in some ways, it's a meeting with your executioner, so to say. So it all depends on sort of what the issues are, how it can be approached, where the parties are at in terms of trying to come up with a resolution. It is worth discussing a federal program called the Rental Assistance Demonstration Program. This program basically converts public housing to a Section 8 subsidy with project-based vouchers or project-based rental assistance. And residents of what we call RAD, or Rental Assistance Demonstration, RAD, they have a combination of public housing and other subsidized housing protections. So the intent of Congress was to preserve public housing rights, but also to allow private entities to invest in the capital needs of public housing. And so this is kind of a federal program that Congress came up with to help do that. So I've talked about eviction from housing, but I need to distinguish between eviction from housing and terminations of housing assistance with vouchers. So those benefits are distinct from residential leases. So participants in voucher programs cannot have voucher benefits taken away without termination procedures. And this is a separate administrative, non-judicial procedure for the termination of voucher. So I discussed project-based vouchers and how that can be confusing. So if a tenant of a project-based voucher unit breaches a term of the lease, they may get a notice of termination from the landlord. They may get a notice of termination from the public housing authority. They may get both at the same time. And really, those are two separate processes. The notice of termination from the landlord is to evict the tenant from the unit, and the notice of termination from the public housing authority will be for the purpose of terminating the resident's participation in the voucher program. I will also note that for properties under this RAD program, sometimes the landlord and the housing authority are the same person with this project-based voucher. And so you may get two notices, one about the voucher termination, one about the eviction, and it can be very, very confusing for residents because they may come at the same time, they may not come at the same time, they may run concurrently, they may not run concurrently. So a little hard to figure out if you're getting all this paper and you're not really well versed in how all of these programs sort of operate together. So it can be overwhelming for people. Because I'm a fair housing attorney, I would be remiss if I didn't talk about fair housing rights for people with disabilities. And this is sort of the general thrust of housing right, fair housing rights for people with disabilities. A landlord cannot treat a person with a disability differently. A landlord must provide reasonable accommodations and allow for reasonable modifications. And landlords are prohibited from taking retaliatory actions when residents assert their rights. So this relates to evictions in a lot of different ways. So sometimes, I still hear it, we'll hear landlords say, well, the person is too disabled to continue to live here, and so we're going to evict them. That's disparate treatment and unlawful. Sometimes tenants need reasonable accommodations to comply with the terms of their lease. And there is a lot of case law out there about how tenants with disabilities may need accommodations even though they are facing termination and eviction from their unit. And then finally, it protects tenants from retaliation. So the Fair Housing Act protects tenants from retaliations. And also there is a prohibition on retaliatory evictions in Maryland law. And that prohibition on retaliation extends to even deciding that the landlord does not want to renew a lease. So if a tenant with a disability receives a notice from a landlord saying, you know what, I don't want to rent to the tenant anymore, it is possible that there may be some retaliation going on because the tenant has asserted their rights. And let me give you an example of what that might look like. So in one instance, we had a case where a tenant had a child with a disability, and she needed some accommodations to address his disability-related need. And she wrote to the landlord to request those accommodations. And the next thing you know, she got a notice of non-renewal from the landlord. So it was pretty clear-cut to us what was going on there, and we were able to step in and protect that tenant's housing. So it's worthwhile just to briefly review what the current status of evictions are in Maryland. During COVID-19, the judiciary has gone through a number of phased reopenings to help mitigate the spread of COVID. Currently, we are in phase 3, and the district courts are hearing limited landlord-tenant matters. This includes tenant holding over, breach of lease cases, wrongful detainer actions, and rent escrow cases in the event that local inspections are able to conduct the inspections necessary. And if you've ever been to a failure to pay rent docket, you'll understand why that is a COVID mitigation strategy. They are very crowded dockets. Sometimes hundreds of cases will be heard. That was certainly before COVID. I think they've reduced that docket quite a bit. But on March 6th, the district courts will be moving into phase 5 and resuming full operations. And to the extent that they can handle matters remotely, they are encouraged to do so. I did just want to note that the availability of eviction prevention funds, some jurisdictions still have money left. And so if you have a resident who is behind on rent, then I would highly encourage you to think about helping them apply for emergency rental assistance. And this is something that our office is also helping people do. Some other COVID-related issues that have arisen. There are several jurisdictions who have passed legislation that prevented rent increases during the governor's state of emergency. And finally, legal assistance for tenants who are facing, excuse me, potential eviction. Maryland Legal Aid, Disability Rights Maryland, Homeless Persons Representation Project, Public Justice Center, Pro Bono Resource Center. There are a number of resources out there for tenants who may be facing an eviction. Frankly, there's more than even these agencies can handle. But you know, the first step is asking for assistance. So that takes me to the end of the presentation. I'll stop it there. I see that we have a couple of questions already in the chat. And Chelsea, do you want to sort of walk us through all of that?
Sure. So I'm going to go and just make sure that I go through I tried to direct people's questions to the Q&A so it would make it easier for us to answer them. A couple people asked about just the PowerPoint being provided. David, is that something that you'd be able to do?
Yeah, not a problem.
Okay, great. And this is recorded, everyone. So this will be added to our YouTube channel for viewing at a later time. Amanda Seymour asked, what if there is no lease agreement? So what is somebody's rights in that situation?
That's a really good question. So Maryland recognizes leases whether they are written or not. So if someone is living in a residence with the permission of the owner of the property, then there may in fact be a lease there, right? Whatever they agreed to when the person married, because you don't have documentary evidence to say what the terms of that agreement is. And so there may be a little he said, she said. In some instances, it may be that a resident is living on the premises without someone's permission. Even there, Maryland requires that owners of property go through a judicial process to eject that person from the premises. And that's called an unlawful detainer action or wrongful detainer. One of the things that we have observed is that sometimes there will be a dispute about who has the right to actually be at the premises. So there may be a tenant, and the tenant may have some guests who are not identified on the lease. And the landlord will try to eject those guests using a wrongful detainer. That is not correct. Really, the remedy for the landlord is against the tenant. And if there are provisions in that lease that prohibit the tenant from having unauthorized guests or unauthorized occupants, then the landlord would need to seek to evict the tenant for having unauthorized guests, not to evict the unauthorized guests themselves through this unlawful detainer. Because how's the sheriff going to know who the right person to eject from the unit is? So that is something that we frequently see, and we frequently have to do some education there for landlords about what the appropriate procedures are.
Okay. Isha Clark asks, will you go over what constitutes tenancy? In other words, what are the rights of someone not on the lease who refuses to leave, like a squatter? Sort of a related question, but.
So, right. So a tenancy is created by agreement between the landlord and the resident. So the court will kind of look at whether there is in fact a landlord-tenant relationship. That's best proven by having a written lease. Sometimes you don't always have a written lease. Sometimes this issue of tenancy can come up in hotel settings where people will be living for a very long time, and maybe they are tenants, maybe they are not tenants. And really the court kind of gets into, well, where are you making your domicile? Where are you keeping your stuff? Where are you listing your address? So those are some instances in which this question of tenancy can come up. If sometimes we've had scenarios where we have clients who are unable to get their guests out of their home. And in that event, that is where the tenant could file the unlawful detainer action against the guest in their home. So the tenant would be saying to the court, I have the right to exclusive possession of the unit. This person is here. They won't leave. And now I am seeking the court's assistance to help me eject this person from my home. So those are some instances that we've seen. But the question of whether or not there is a tenancy, it really requires agreement from both the owner of the property and the person who's going to be living there. And that agreement is best put in writing, but it can be oral.
Very good. Kristen Kenyuk asks, if the landlord applies rent to something other than rent, are they required to notify the tenant in advance?
So I think there are a couple of different thoughts on this. Ask a landlord, and they may, depending on the landlord, they may tell you no. Ask a guy like me, and I may tell you yes. This is really sort of a very much debated issue. There are some cases out there that seem to suggest in Maryland that a landlord's obligation, when a tenant presents a payment that is clearly intended as rent, that it be applied as rent. But there is not that firm holding from Maryland courts that say those payments from a tenant to the landlord that are in a periodic set amount constitute rent. So is the landlord required to give proper or prior notice before applying the rent to something other than the tenant's rent? What you will usually see is leases that say everything you could ever owe me as your landlord, that's rent. So if there are administrative fees, if there are any other kind of fees, I'm calling that rent. And I can evict you if you don't pay those administrative fees or those other fees. And Maryland courts have not said landlords are prohibited from doing that. And there is no legislation that prevents landlords from doing that. So in terms of notice about that, if it's in the lease, then that is a practice that landlords may engage in.
All right. Anna Patton asks, can you define material breach and what would make it substantial?
Really good question. So a material breach is usually something that is material to the terms of the agreement. And so, excuse me while I go back. This is really going to depend on how the parties interpret the lease. So if I can think of, go back to my example of no potted plants on your balcony. It's not a material term, not really. You know, it's more along the lines of a house rule. A material term may be something like, don't commit criminal activity on the property, or pay your rent on time, or only you can occupy the residence. So those are essential terms to a lease. Substantial, you know, again, this is something that a judge is going to have to decide. So let's say, for example, we say someone does have a guest beyond what the lease allows. The lease may say you can have overnight guest for 14 days, but no more than 14 days. Let's say someone has a guest for 24 days. Is that a substantial breach? That's something that a judge is going to have to decide. And he's also going to have to decide if it warrants an eviction. Now, you know, I think it would be fair to say the person's no longer living there. So what exactly is the issue? And, you know, that's something that would need to be decided by the court.
Okay. Sorry, one moment here. I'm going to hop over to the Q&A just to add, there's so many questions. I'm trying to answer some that I can answer. Daphne Dorange asks, if the lease grants a 10-day grace period, is this notice issued on the first or should it be issued at the end of that grace period?
I think, Daphne, you're talking about the notice of intent to file a complaint.
She says yes.
Okay, great. So let me think through that. I think that if the lease allows for 10 days before rent is due, that 10-day grace period, then the landlord would need to wait for that grace period to expire before they could send this notice of intent to file a complaint. Because basically the parties have agreed, you know what, I get the first 10 days of the month to pay rent. And I have not failed in my obligation until the end of that 10th day. Then the landlord would be entitled to file a notice of intent to file a complaint. However, I would just add this note of caution that there is in most jurisdictions, there is legislation that prohibits the imposition of late fees over a certain period of time, 5 days or 10 days. That's not the same thing as a grace period to pay your rent. What those statutes basically say is you're not going to have a late fee imposed if you pay rent on the 5th. That doesn't mean that rent's not due on the 1st. So it may be that your lease says rent is due on the 1st of the month. You don't pay it on the 1st. On the 2nd, you get this notice of intent to file. And you pay your rent on the 2nd. The landlord cannot then assess those late fees against you for paying rent on the 2nd. But he would be within his rights, or the landlord would be within their rights to send that notice of intent to file.
Okay. An anonymous attendee asked, if a resident verbally threatens the staff with, "I'm going to shoot up the office and staff," is there an emergency eviction act that can be filed to have that individual removed within 14 days or less? The tenant has been a holdover for months.
No.
No. Okay. Etta asks, regarding the environmental adaptations funds from the CO waiver / community first choice, if the landlord refuses or insists that the changes be removed upon the participant moving from the location, is that something that falls under this provision? I'm not sure if I understand what provision you're referring to, Etta. maybe I can.
Well, so yeah, so I think I can answer that.
Okay.
So under the Fair Housing Act amendments, landlords cannot refuse residents the right to make reasonable modifications, which I think Etta is referring to. However, the Fair Housing Act amendments also allow the landlord to require the tenant to pay a certain amount of money into escrow to restore the premises to their original condition. I think there can be a little bit of negotiation here with the landlord. Maybe there's a longer lease term that he would like to have. Maybe, you know, there is benefits to having something simple like a grab bar or something else in the shower that other residents out in the community would like to have. So there can be a little bit of negotiation around this issue of paying into an escrow to have the premises, restored. Now, if it's something on the common area, if you need a modification to the common area outside of a dwelling unit, that's different. The landlord cannot require you to pay into any sort of escrow account. The reasoning being is we want to increase accessibility generally for people. We don't want to decrease it. I think maybe when the Fair Housing Act amendments were passed, there was some concern about modifications that may affect marketability of units for people without disabilities.
Okay. Kristen asks, if a landlord passes away and another person takes possession of the property per a will, does the surviving beneficiary have to honor the current lease? That's a good question. Yes. Okay. Cynthia Williams asks, what if the unit fails inspections and the landlord never does the repairs, nor does he take you to court for non-payment of your rent? What do you think he's planning to do?
Oh, this is a very good question. So, you know, those can be very tough arrangements. So, you know, what we have seen more of is unlicensed landlords operating substandard housing for people of extremely low income. And landlords are basically prohibited from filing any kind of failure to pay rent case against tenants who are withholding their rent because of the conditions in the property. A tenant is not prohibited from filing an escrow complaint in the district court where they are residing. But what the court would probably require is that the tenant start paying rent into the escrow account for the court to then order the landlord to make the repairs. So, you know, if the tenant has been withholding rent for several months and has that rent that they've been withholding and is ready to put it into an escrow account for the judge to order repairs to be made, then that may be something for them to consider. If, on the other hand, the tenant is feeling other pressures and doesn't have the rent saved up to put into an escrow account, you know, it's a really unfortunate circumstance, I think, for everybody all around.
Okay. Etta asked if, and this is not really an eviction related question, but it's a good question. If the person holding the Section 8 voucher passes away and there's a second person on the lease, can they take over the voucher?
So typically, if that person is part of the household, then yes, the voucher would go to the the household. We have had instances where a tenant will ask a family member to be a live-in aide, and under federal regulations, live-in aides are not considered members of the household. So you may have a mom and daughter living together, and the daughter is acting as a live-in aide for the mom. Mom passes away. Daughter is not part of the household because she was out there as a live-in aide. And so that's a much harder circumstance. And the daughter may not be entitled to receive that voucher benefit.
I know that we're over time. David, are you good to answer a couple more questions?
Yeah, for sure.
Okay. Aaron Ashinghurst asks, what if a person comes home to find themselves locked out of their apartment and the leasing office says they're in an eviction process before being properly notified? What are the next steps, or what is allowed?
I'm sorry, Chelsea, I may have been looking at something else. Could you say it again for me?
Oh, yeah, sure.
Apologize.
What if a person comes home to find themselves locked out of their apartment and the leasing office says they're in an eviction process before being properly notified? What are the next steps, or what is allowed?
So you should definitely contact an attorney's office there. Maryland does not allow non-judicial evictions. They do not allow landlords to change locks. They do not allow landlords to turn off power or otherwise prevent a resident from accessing their unit. That all has to be done through the courts, and only a sheriff can physically evict someone. So if you know someone who has experienced that, please refer them to a law office for potential representation.
All right.
And just to reiterate who those agencies were, there they are.
Great. Margaret Boyle asks, can a landlord evict a tenant with disabilities in the process of porting their housing voucher back to Baltimore City, who has not received notice of the status of the reported voucher yet and has not yet been provided another reasonable accommodation from their housing relocator? This sounds like a very specific situation.
Yeah.
Maybe. Yeah.
So the voucher and the landlord-tenant relationship are, there are some separate tracks there that they can run on. So a landlord could exercise some of the rights that they have, regardless of where things may stand with a voucher. I'll just, from my experience, there's never a smooth port from one jurisdiction to the other. It's always a little bit of a rough process.
Another question from Eric Brooks. Is the eviction notice and warrant of restitution the same? Can it be used when a customer applies for emergency rental assistance?
The eviction notice and warrant of restitution the same. So the warrant of restitution is what comes at the end of a court proceeding, or after all the court proceedings and a trial has been held. So if the only thing that has happened is that the tenant has received a notice or a summons from the court to appear on a certain date, then that is not an eviction paper, and that's not a warrant of restitution. The warrant of restitution will say there is a judgment on this date. You know, I'm authorizing the sheriff to take these actions, and you've been notified of it. And to your second question, yes, any of these notices that a tenant may receive, whether it's the pre-filing notice for failure to pay rent or a summons from the court for a failure to pay rent trial, then those are all things that should be shared with the local emergency rental assistance program to try to get folks on potentially a fast track to receive the emergency rental assistance.
Okay. Gary Butner asked about a parent evicting a child who has lived there since childhood. I guess he's asking if this is a legitimate thing that can be done.
Well, so
unique situation.
I guess there are some. I have some questions, but you know, I don't know if we're talking about a minor or someone who's
right
of 18. But I would, you know, if there's a landlord-tenant relationship, then you need to go through the eviction process, and you know, if someone does not have the right to be in the unit, either because they're not a landlord or not a tenant, or because they don't have any sort of what's called possessory interest, then the person could utilize unlawful detainer procedures.
We got a question about, is there any ordinance called a notice of good cause?
So, not in Maryland.
Okay.
So, the ordinance or notice for good cause, that would be similar to this that we discussed. Some states do have those notices of good cause. New Jersey is one of them. And what that means is the landlord has to have some reason to evict you at the end of your lease. I've tried to make the argument that Maryland has essentially this, and I got laughed out of court. So, you know, that's Maryland does not have a good cause provision for termination of leases at the end of their term.
Nicole Brittingham asked, can a landlord make the remaining household member pay an outstanding bill if the remaining household member were minors at the time of lease signing but are now 18? Also sounds very specific.
Yeah, sounds like someone passed away, maybe.
Yeah.
Well, I think that gets into questions of estates, and I would, you know, my general take is that heirs to an estate inherit all the obligations of the deceased, and so if they're capable of being heirs and inheriting all the benefits of the estate, then they probably inherit the obligations as well. So.
Okay, only a couple more, and then we will have
Sure.
to wrap up, everyone.
Yeah.
Can an eviction occur if a secondary family member who is not residing in the house evicts the family member living there due to selling the house? for the example is that the mom and the daughter reside, mom dies, daughter is told to leave by brother who sold the house, daughter is disabled and receives SSI.
Yeah, so if daughter does not have some sort of possessory interest, which would be like being on the deed or the title or a lease, then they don't necessarily have rights to continue to reside there.
Okay, Cynthia Williams, if the landlord is requesting someone to do something that is not in the lease, like getting a storage unit because you have too much stuff in your unit, does the tenant have to get a storage unit, or would they be threatened with eviction?
So in order to evict someone in Maryland, I'll just kind of go back to why they can do it. You know, you've breached a term of your lease is ending, or you haven't paid rent. So unless there's some lease term requiring the tenant to do something, you know, the tenant doesn't have to do it. But the landlord may decide, hey, you're not being very cooperative, so at the end of this lease term, I'm not going to renew your lease.
Okay, last question. If someone is in a program like a continuum of care for housing, is approved to go outside the supervising county due to a lack of housing during COVID, and there are no tenant landlord disputes, can the continuum of care program later force the tenant to return to the original county at the tenant's expense or terminate the client from the program?
I'll confess my ignorance. I don't know the answer to that question. And I think that's, you know, I'd be interested in hearing more. If you'd like to reach out, I'd be happy to answer any questions you have on that.
All right, sounds good. Okay, well, everyone had some really great questions. It sounds like we need to offer this session again. For those of you asking, I will, once David sends over the PowerPoint, I will send that out to people who have registered for this particular session today. So you will get copies of it, and it does take a while to process the video to send it, to put it on YouTube, but it will be on the MDOD YouTube page. And I will send out David's contact information. It's right there if you all need to take that down. Any specific questions, definitely get in touch with some of the legal services organizations that David had listed there if you're helping a client and they have a legal issue that is very specific and needs to be examined by an attorney who is familiar with the situation. So thanks everyone for coming today, and we will reconvene for another training session, I'm sure, in the next couple weeks.
Okay, thank you, everybody.
All right, thank you. Take care.